Thank you, Wes, for your remarks. Good morning, good afternoon, good evening, dear colleagues, wherever in the world you may be. On behalf of the Teaching International Law Interest Group of the ESIL, it is my pleasure to have Professor Daniel Bradlow to talk on taking students beyond their comfort zone, a very interesting, thought-provoking topic. Without wasting further time, I would invite Professor Bradlow to deliver his talk. And for sure, we are looking forward to a very interesting discussion to your questions on Professor Bradlow's presentation. Danny, over to you.
Thank you, Rizwan. To begin, I'm just going to share my screen. Can you see the slides? Great. So firstly, I want to thank the Teaching International Law Interest Group very much for arranging this talk, and to thank Rizwan for selecting this topic, which I have to say has pushed me beyond my comfort zone and forced me to think much more critically about what I hope to achieve as a teacher and as an international lawyer. And also it's forced me to make a much more personal talk than I think almost all the talks I've given in my career have been about. So just to give you a quick overview, what I want to do is to define a couple of key terms to begin with, then talk about what I think our task as international law teachers is, some of the challenges that we face, and then draw some examples of how I teach to illustrate some of these points, and then come to a conclusion. So the first thing is, what do I mean by a comfort zone? So it's the area in which we are intellectually and emotionally at ease. I want to focus on the intellectual part, but I recognize that the emotions and the intellect are not that separate, that they're not implicated together in this. But the challenge with being in your comfort zone is that it leads to us having conscious and unconscious biases that risk distorting our understanding of the problems that we're seeking to address, that reduce the rigor of our analysis and can cloud our judgments on the issues and the conclusions that we come to. I feel because of the nature of this talk, I should also make a disclosure about what my comfort zone as an international lawyer and educator is. And so to do that, firstly to say, I define myself in my area of expertise as international development law. And within that, I focus on international finance and human rights, and on international financial institutions and accountability. My entire career, I've operated and taught in a multicultural and multinational and multidisciplinary environment. And I would just add as a footnote to that, that by far the most challenging of those is operating across disciplines. We can come back and talk about that later. Final point to note in terms of my own comfort zone, as a sense, is that my guiding principle as a teacher and as a lawyer is Marx's 11th thesis on Feuerbach, which is that philosophers have hitherto only interpreted the world in various ways. The point, however, is to change it. Second thing I want to do is define what I mean by a responsible international lawyer. So that's a lawyer that's technically knowledgeable about international law, who knows how to use the law to meet their clients' needs, and to do so in a way that's consistent with principles of justice and sustainability. And that means that they need a responsible international lawyer has technical skills, and we'll have to talk a bit more about what the skills that an international lawyer needs are, and has the values to act consistent with principles of justice and sustainability. I just note as a footnote to this, but we can come back in question time if people want, is what do we mean by international law? Is there really an international law? Or as Anthea Roberts has taught us, are they merely a collection of different national and regional views of what international law is? But that we can come back to later. So given all that, what's our task as international lawyers? The first one is, our task is really to prepare students to practice international law responsibly for the next 50 years. That'll be the 50 years of their career. Now, not all of our students are going to become international lawyers, Not all of our students are necessarily even going to practice law in any way. And the way in which they practice international law, if they do practice international law, is going to be very varied indeed. Given all that, I think it's also important to keep in mind that we're teaching them international law, but we're just one of a cadre of teachers who are teaching them how to be lawyers over the course of their legal education. But that our job is to make sure that if they do want to become international lawyers, they have the skills to do that. And the skills that they need is firstly and most basically is a knowledge of international legal doctrine. And I recognize just stating that is glossing over all sorts of issues that we should be discussing, but that in general terms is the basic thing we need to do. Second thing is we need to make sure that they understand the context in which international legal principles and doctrines will be applied and how they interact with those contexts. Third thing is they need the basic skills that any lawyer has, because clearly we do not know what international law will look like 50 years from now or how it's likely to change by the time they graduate from law school, let alone by the time they're well into their 50-year career. So that we need to teach them how to research and analyze international law, how to write as international lawyers, so how to build legal arguments, how to draft treaties and other sorts of agreements, how to negotiate within the context of those agreements. They need to have the flexibility to think critically, laterally, and to be open to new ideas as things change over the course of their careers. And they need to be able to operate cross-culturally in both a legal and a non-legal cultural sense. And in thinking about that, when I say culture, legal culture, I don't mean legal traditions such as Islamic law or civil law or common law. I mean the different cultures that exist in different countries around how the law operates. And to illustrate that, I thought I'd give an anecdote from when I was the director of the International Legal Studies program at American University. We used to have 60 students from 60 different countries in the program in each incoming class. And one of my most important tasks during orientation for those students was to make sure that they all understood the significance of the American University's honor code and how it could affect them over the course of their studies. And one of the things I realized is understanding the words of the honor code was easy. It was pretty obvious what they meant, and most people could do that. But the way in which students interpreted and applied the honor code was completely different. Some students would say the purpose is you have to stick to the letter of the law. You can do whatever's allowed up to the limit of the letter of the law. And if you go beyond that, then you deserve to be punished in some way. Other students would say, no, that's not good enough. You have to follow the spirit of the law. And that means that you have to stick, there's a zone within inside the bounds of the honor code that honorable people would follow. And that boundary ends before the law, the end of the word of the law. There's a penumbra around the honor code, which are essentially viewed as shady practices or unethical conduct by lawyers that's technically legal, but that would be something that honorable people would not do. Other people, on the other hand, would say, well, all the honor code really is a series of guidelines on how we should behave. If we run into any sorts of problems, then we can sit down and discuss what the problem is and work out a way to deal with that. It's not really there as a disciplining tool. And one of the things I realized is that the way these students were looking at the honor code was based on the way in which in their legal system and legal experience was the way in which contracts were seen by their different societies. And so that's, when I talk about culture, that's what I'm talking about legal culture. The second part of our task is teaching values to our students, is to teach them about that they have an obligation to be responsible, to meet the obligations or the needs of their clients, but they also have a responsibility to the legal system more generally and to the societies in which they operate. They also need to have some sense of understanding of justice. And what's a new thing, I think, is a sense of understanding of what do we mean by sustainability in a legal context. And that's not just about environmental sustainability, it's social sustainability, economic sustainability, cultural, in other words, a holistic view of sustainability. And I would say on all of these issues, there's not necessarily a correct answer. But the point is that students need to be pushed to think about what are their values, what are the issues that they should be thinking about, and how do they form judgments about this for themselves and for their careers. So within that, here are some of the challenges that I think we face as international laws and teaching international law. The first one relates to the subjects and sources of international law. So historically, we've been taught that states are the primary source of international law. But does this really make sense? I mean, if you look, none of the states that were the key protagonists in the Second World War have the same boundaries today that they did at the time of the Second World War. Within all of our lifetimes, the boundaries of states have changed. Those of you who are too young to remember the end of the Cold War have witnessed South Sudan breaking away from Sudan, have witnessed the breakup of Yemen, have witnessed Eritrea breaking away from Ethiopia, and possibly further breakups in Ethiopia now. So the boundaries of states are never as clear and stable as we think. Second thing is things like TWAIL, Third World Approaches to International Law, Law from Below, feminist approaches have taught us the way in which states make international law is not fair, it's not peaceful, it often involves violence, it's sometimes definitely not consistent with principles of the rule of law. And so is there a reason we should really privilege states in the making of international law? And in that regard, I'd mention also that the rise of the Global South as an actor and as an important force in the international affairs suggests that non-Western legal traditions are becoming much more important. And it's not necessarily true that they all are based on sovereign states as the building block of international law. Against that, though, I would say if you look at the activities of the BRICS or of the new international economic order in the past, the strong emphasis on state sovereignty in developing countries, I would say is in many ways problematic, but it's also that sovereignty in some ways is seen as their only protection against powerful states. And so that raises some questions as well. In terms of actors and subjects of international law, the other important development that we need to take into account is the rise of non-state actors. Now, international organizations have been seen as subjects of international law for many years, but corporations, civil society groups, individuals are not, their status as under international law is still an evolving concept and something that we haven't fully worked out yet. But it's an issue that's becoming much more important, and certainly over the next 50 years is like to become even more important. Just to give a few examples, we know that because of technology, because of communications and information technology, the ability of these actors, of states, of corporations, civil society groups, of individuals to evade the authority of the state and to make standards of conduct and practices that are inconsistent with what states want is becoming much more powerful. We know also that the globalized economy and financial system is making states less significant in many ways, but not insignificant. And just to give one example, if you look at how the response to the COVID pandemic or the economic consequences of the COVID pandemic were handled, the key actors by far were not states or international organizations like the IMF. They were the central banks and financial institutions that make up the international financial system, which moved way more money quickly than the IMF or states were ever able to do. Finally, the third one, which suggests that non-state actors are going to become even more important, is climate change. We know that states alone cannot solve the climate change problem, that corporations driven by civil society, by individuals, are absolutely essential to dealing with climate change, and in many ways are driving the way in which climate change is being managed. The couple of things also to keep in mind about climate change that really have some potentially profound implications for international law. One is that climate change is the first truly global issue. It might be terrible and very unwise, but we know it is possible for states to choose to unwind the globalization of the financial system, to cut themselves off from the financial system, to nationalize technologies and fragment the internet so that the world becomes less globalized rather than more globalized. Even with pandemics, we know states can shut their borders and more or less significantly stop movements of people and movements of disease. Not totally, but significantly. Climate change is the one issue that you cannot do that. The impacts of climate change will transcend national borders no matter what states do. And so that means it has to be dealt with comprehensively, and that all actors have to be involved because they all have the ability to affect the way in which climate is dealt with. Secondly, we have to think carefully about what we mean by climate change. Do we just mean the carbon emissions and reaching the outer edges of the carbon budget for the world? Or do we really mean talking about all the environmental and social impacts that those carbon emissions are leading to? And if we're talking about the latter, that means changing the way in which production takes place, the way in which consumption takes place, the way in which we interact with each other, all of which will, and I would submit, we don't have an option. We have to do that whether we like it or not, and that has serious implications for international law. And the lawyers that we are training are the ones who are going to have to deal with that. So that leads to two questions, really. One is, are non-state actors becoming as important or maybe even more important than states as makers of international law? And as the sources of international law, does it mean soft international law is becoming more important in many ways than the classic sources of international law? Final challenge that I want to talk about is that and this is true of all legal teaching, I think, we tend to teach international law looking backwards, but the practice of international law is done forwards. And by that, I mean, most ways in which we teach international law is to look at disputes, how they were resolved, whether it was in a court decision or in a treaty or in a resolution or whatever it would be. But the issue is resolved in some way, or at least partially resolved. The way in which we practice international law and the way in which clients want us to practice international law is to think forward. How do we apply those to help clients meet objectives going forward? Not always. Sometimes there's a dispute that's arisen and we have to look backwards, but a lot of international law is looking forwards, which means we want to know, how do you apply those principles in order to achieve a non-legal objective often? So that you need some understanding of how the law interacts with non-legal issues, with the business issues, environmental issues, human rights issues, security issues. And that means that a critically important part of being a good international lawyer is knowing how to assess risks in situations of uncertainty and how to exercise judgment. And that means the ability to warn clients about risks and to accept the possibility that clients have different views of those risks from the lawyer. And what do you do when the client is willing to take on risks which you think might be unwise or maybe even unethical? How do you manage that? And what are your obligations as a responsible lawyer doing that? So to answer this, the only way I could think of doing this was to look at 4 book projects that I've done that give answers to the ways in which I've tried to do this. So the first book is The International Legal System that I'm a co-author of with Mary Ellen O'Connell, Naomi Roth-Ariadza, and Diane DeCierto. And this is the 8th edition of this book is coming out soon. And we've tried in this to look at new ways of dealing with non-state actors. And to do that through looking at international organizations and their relationships to non-state actors. For my purpose, particularly with communities in member states, and to ask, why is it that international organizations were set up not to deal, on the assumption that they would not deal with communities directly? They would only interact with the citizens of a country through the government of that country. And that is no longer true of almost any international organization we can think of that is involved in operations in its member countries. What are the implications of that for immunity and accountability of those organizations? Should they have the immunity that they have? And are there ways to hold them accountable when they cause problems? And we know that they cause problems. And what are the implications of that for the sovereignty of states? Second way to do that is to think about the guidelines on business and human rights and the question of what are the extraterritorial obligations of multinational corporations. What happens when they want to operate in another country in a perfectly legal way under the home law of that country, but inconsistently with the principles of business and human rights? Should the sovereignty of the state trump those international principles? And what are the obligations and how do we manage that going forward? Second issue in terms of teaching international law forward is I developed a course around a simulation exercise, a simulated negotiation of an international business transaction, which with one of my co-teachers, Jay Finkelstein, we turned into a textbook. And the value of this as a teaching tool is it forces students to sit and apply and in sort of a semi-realistic setting, the legal principles, and to think through some of the complicated questions that come up as you do that as a lawyer advising a client. So what happens, for example, if as I said before, your client wants to do something that's perfectly legal under the applicable laws, but violates international standards? What are the realities of some of the trade-offs of time of different principles and of time horizons that exist in this? So what happens if your client has a project that is going to produce profits very quickly, but over time is going to cause serious environmental problems? And your client says, look, it's going to take 10 years for the environmental problems to come up. My plan is to exit this project in 5 years. And so what do I care about the environmental problems? I'll be long gone from the country by the time they arise. What are your responsibilities as a lawyer in that situation? To challenge students to think more about human rights issues and how they should be applied in practice. And this is not in this exercise, but from another example I often use when I teach is to say to students, so imagine you've got a client who's come up with a miracle drug that's made from an agricultural product. It's perfect product. It's going to cure the disease and no side effects. But on the farm where we bought to produce this product, we're going to build the factory. And in order to begin production immediately, we're going to fire our choice is we're going to fire all the workers, hire factory workers, and begin production immediately and distribute the drug around the world to the people who desperately need it. The alternative is we could keep the workers on the farm, train them to work in the factory, and delay production for a year for that training, and then begin producing the drug and distributing it. Which one of those is better from a human rights point of view? Should we allow the right of the workers to have a decent job trump the rights of health of the people who would get access to the drug, or the other way around? I don't know the answer to these questions, but these are very real questions that come up in some form in many ways, and that is ways of pushing students outside their comfort zone, but asking them to think about issues that they could face in their careers. Third one is a book that I grew out of a discussion with a colleague, David Hunter, about teaching about the difference between soft law and hard law, and what I call the seductive power of hard law. That most people think getting a treaty is always the best option because it's enforceable and there's liability that follows from that, and that's always a good option. And there's no question that in many situations that is the best option. And if you think about international criminal law, the Rome statute couldn't exist if it wasn't in the form of a treaty with a criminal court that had teeth like that standard legal teeth. On the other hand, if you think about international business and human rights, we don't know how companies should actually implement human rights. We're still learning how to do that. If we put that in a treaty, there's a real risk we could end up with the lowest common denominator in a treaty, and it's very hard to change treaties. So that's whether that's the best option, or we're better off with a soft law option that allows for a learning process is an open question. Secondly, it's not clear at all that soft law is less enforceable than hard. It's clear that as a legal matter, it's less enforceable, but de facto, it can be even more enforceable. The power of reputation and the role of market forces can have a huge impact on how governments behave. In South Africa at the moment, we're facing the risk of being grey listed by the Financial Action Task Force, which deals with anti-money laundering, because our laws don't comply with the FATF guidelines on anti-money laundering. The fact there's no legal liability. Nothing happens legally if we don't comply with those. But the fact that we're about to be grey listed is forcing the government to apply with as much power, with as much force and determination as it can to get a complicated law passed very quickly, because the consequences of being grey listed in terms of its impact on the state's ability to borrow and the consequences for the South African financial and corporate sector, and therefore on jobs in the country, is potentially huge. And so the fact that it's legally unenforceable is irrelevant to the country and its thinking about these issues. The last one, which I'm going to skip over, other than to say this last book, which I did with a postdoctoral fellow working with me, Magali Masamba, is a book on sovereign debt and in the SADC region. And one of the reasons I wanted to include this is because it's a way of getting young scholars and young lawyers, particularly graduate students, to think about complicated issues, write articles on topics that they might not think about in other ways, and get them to promote new thinking on these issues and new scholarship on these issues. So finally, to end, I would say we have a responsibility, given all these challenges, to make students intellectually uncomfortable enough that we challenge their basic assumptions about the law, their professional responsibilities as lawyers, and their responsibilities as citizens of the countries and the world as a whole. As I said before, there's no correct answers to these questions. Each student must come to their own conclusion, but each of us as teachers and each of us as students has an obligation to think carefully and rigorously about these issues and come to their own conclusions. And with that, Rizwan, I'm going to stop. And I'll stop sharing the screen as well.
Thank you, Danny. Maybe one way I would sum up your presentation is that we can encourage students to think. Maybe that's one of our functions. Instead of teaching them, we can help them to think and think more critically. Over to you, Dr. Titi, for your comments and observations on Danny's presentation.
Thank you very much, Rizwan, for the kind invitation. And I'd like to commend the work of the Teaching International Law Interest Group of ASIL. I think you're doing excellently in disseminating knowledge and information about international law. I'd like to thank Professor Daniel Badro for his excellent, stimulating talk as well. I learned a lot, and I'm delighted to be given the opportunity to comment on his piece. So two core themes that I drew out from your talk was content and value. Content, what is the subject matter of international law? Why should we teach the types of international law that we teach? How should we teach international law? What informs the choice of our teaching style and approach? The second is value. How do students implement the knowledge that they have been taught? So how do you translate it from theory or from the classroom into practice, into action, or into everyday lives? And Overarching those two central themes, you drew pertinent examples to make cases for the different ambits on content and value. Now you expanded on what the comfort zone and responsible international law would look like. You talked about your own subject specialties, and you used that in making the analysis that was presented. And I think I'll draw from that in just my response to you as well. I'll start by saying that international law is political. It often reflects the interests of powerful states and actors. You've mentioned both state actors and non-state actors. It is also grounded on plurality. There are different theories, methodologies, methods, and approaches that can be employed to unpack the diverse aspects of international law. In addition to introducing students to the heterogeneous international law landscape, we can also encourage them to explore and provide the platform for them to develop independent positions and perspectives. I'll draw from my experience. I was introduced to critical international law scholarship during my master's in international economic law at the University of Warwick. I was particularly drawn to international intellectual property law, as was taught by the late Dr. Dwijen Rangnecker. Dr. Rangnecker was a world authority on plant variety protection and geographical indications. In fact, his work remains one of the most cited on geographical indications. He spent most of his last decade on Earth researching and writing on how geographical indications could be utilized by local producers to protect the production and cultural identities of geographically specific foods, including feni. Feni is a liquor produced from cashew nuts and the coconuts in the Goa region of India. I would not go deeper into his scholarship on geographical indications, but what this did for me was it sparked an interest. It was the first time I was connecting different aspects of my interests. I'd always been interested in food and agriculture as a child growing up. I studied law, so my background was Black letter law. I did that for my LLB. And during my master's, there was a crystallization. There were points that connected. And I'd never thought about the impacts of law on people on the ground, on farmers, on small-scale producers. And I think that Dr. Dwijen Rangnecker achieved this goal of creating international law in a way that pushed me out of my comfort zone. So creating an interest or generating an interest in international law in a way that I had not thought about international law. And I think it has made me, if I can say, a responsible international lawyer. Professor Bradlow talked about some of the critical theoretical frames on international law. I would expand on one: third world approaches to international law. Professor Tony Angie, in his 2017 Ben Bernard Memorial Lecture at the University of Cape Town, South Africa, reminded us that theory provides the lens and the conceptual tools to engage with international law. He notes that international law, which has often facilitated the achievement of the goals of the much more powerful societies and states, was extended throughout the globe as a result of the colonial encounter. Accordingly, understanding and exposing the technologies and colonial devices of international law is crucial to achieving an understanding of the nature and current international legal regime. Professor Sunaraja also explains that international law that was shaped in the colonial era was not a neutral discipline. It was an instrument of naked power, skillfully dressed up so as to hide the objective of the controlling the colonized world for the benefit of the colonial power, and through the projection of power, that the subject of law was important in projecting what would otherwise have been the necessary interest of the powerful actors. And it also was trying to hide the type of dissent and contempt for the rules that could have been provoked. So we see that the history of international law is not neutral. And I could also draw from other third world scholars. Professor Obiora Okafor notes that TWIL, third world approaches to international law, is a broad dialectic of opposition to the general unequal, unfair, and unjust character of the international legal regime that often helps subject the third world to domination, subordination, and disadvantage. You could also look at Professor James Gathi's scholarship, and he has talked about the ongoing debates around the questions of power, identity, difference, and what this means for international law. And so in going back to the core themes of content and value, what should we teach students? How should we teach students? What values will students learn from our approaches to international law? I think that it would be our responsibility to, first of all, have rigorous research-led teaching. And by this, I mean that as subject specialists, we could dip and dive deeper in our teaching. So, for example, Professor Bradlow has shared volumes that he has worked on and that he uses in his teaching. And I think those are examples of how research can be translated in teaching and how those can also spark the interest of students. And I would say other things that could be, or methods that could be employed could be collaborations like what Professor Bradlow has done with Magali on the work on sovereign debt in the SADC region. So collaborations would help both younger scholars, younger practitioners, early career researchers, students, give them the leverage of experience and access perhaps to some information, some empirical research that could help them build their knowledge base and make independent, informed analyses in their work. The second would be students also engaging in independent research. So students going further, doing postgraduate degrees, it could be taught or research degrees. And I think in the process of a taught degree, you're exposed to different subjects in international law. In the process of a research degree, you're embedded in a particular topic and you're learning as you're researching for about 3 to 4 years. And I think that a student already grounded in the content of international law should be able to produce a robust thesis for their PhDs if they decide to go through that route. Now, you could also go into practice. I think a student that has been exposed to content and value in the way that we have explained would be able to translate that into their legal practice or in other practice areas that they choose. Students could also go into lawmaking, into policy making at national, regional, and international levels. I think Africa is at an important, crucial moment in history with the African Continental Free Trade Area. And now we're pulling together our resources, both on the continent and in the diaspora, to draw up the type of international economic law architecture that we would like to see and that emanates from the ground up. An African-centered African Continental Free Trade Area is the goal. And this is already being achieved with the different protocols that have been drafted. The only way that African scholars could have devised or formulated these protocols and the ongoing negotiations would be through the robust knowledge of the content, as we have already discussed. So I think that in these ways, we can see how theory has now led into praxis, or praxis, as we'll say, the implementation of theory. And those could be ways that that international law students who then become practitioners would be able to translate their knowledge into practice. And I think I could sort of end here to say that our teaching would be theoretically informed, methodologically informed, drawing from multiplicities in our methods as well. But finally, I'll talk about our assessments as well. I think our assessments could also provoke students into moving beyond their comfort zone. So one of the assessments that I give in my classes is writing policy briefs. I invite students to write policy briefs and to present those policy briefs. And many of them have come back with feedback about how that has, first of all, how they were uncomfortable thinking about how to draft those policy briefs, or how that has helped them and what they would like to do with those policy briefs when they go back to their home countries. Other types of assessments could be creating posters. One of my favorite forms of engagement is posters, right? And that was what I started with in my presentation as a PhD student. And I think having students write succinctly about their understanding of critical international issues can help them in sort of thinking about the subject. So I would say that creative assessment styles could also help to push students beyond their comfort zones and could help in achieving some of the aims that we are drawing for on this topic that we are discussing, creating responsible international lawyers and the obligation to push our students beyond their comfort zones. I think I can end here and we could talk a bit more. I have some more notes, but I think we could talk a bit more in the Q&A because I can see that the time is fast spent. Thank you.
Thank you, Titi. And one thing I could not agree with you more on is that, as you have rightly said, almost every student, irrespective of what kind of student they are, they would respond to our assessment tools. So maybe that's one way for us to influence their thinking, their learning. Professor Bradlow, the first question that we have is from Ahsan Kazi. He asked that as a teacher of international law in Pakistan, what can he do?
Thank you, Rizwan. Firstly, I want to say, Titi's excellent remarks. I endorse completely, and the idea of being creative around exercises in class and in assessment tools is really important. But I'm also aware, and I don't know very much about law teaching in Pakistan, so I'm somewhat speculating, and I hope this is helpful in answering the question. But one of the things I know is that the number of students in the class either facilitate creativity in the teaching or are a constraint on it. I mean, what you can do when you've got 20 students in a class is completely different from what you can do if you have 200 students in a class. But that doesn't mean that there aren't ways in which to be to challenge students in a big class in a way that you can't do in a small class. And I think Titi's example of getting students to write policy briefs is one good way of doing that. I mean, you can say that counts for 20%, for example, of the grade, and so that you don't have to, you cut back on what you do in the final exam. Another way, which I find, because as someone who doesn't teach a first-year class, but teaches students at the end of their careers, of their student days, is how many law students get to the end of their legal studies and have never looked at a full contract. They might have seen provisions of a contract in a case that they've read, but as you know, you can't understand a contract. You can't really read it unless you understand what's the goal of the contract, what is the parties trying to achieve. And so that using that in a classroom is another way of trying to do that. As I was listening to Titi, I was also thinking, I mean, one of the other ways, particularly if you're teaching in big classes, and I recognize that this is easier in some countries than in other countries, is to use current examples. And we actually have a great example right now with the Queen's death. The writings about, you know, the basically laudatory commemorations of the Queen and her career have been mixed in many countries, but in other countries, people have been talking about, well, what's so great about the Queen? She kept quiet while all sorts of horrendous things were happening in the colonies when she became the Queen. when she was in Kenya, when she actually became the queen. It was not long before the Mau Mau uprising began, and she didn't speak out about that. I mean, some of it, it's the nature of the crown, of the royalty and the monarch in the British system that precludes her from speaking. But that opens up a space for talking about how international law was created, what the status of international law is. Similarly, we can talk about what's happening with China, for example, in Sri Lanka, and dealing with the debt situation, and how many of the issues that are coming up in regard to China are not all that different from the issues that came up in the 19th century around concession agreements in colonies. I'm not saying that China deals with them in the same way that as the former colonial powers did, but there are opportunities to raise the issues and to use those as entry points to get students to think critically about issues which they can relate to and which they need to come to terms with as citizens of their countries, if not as lawyers.
Thank you. The next question that sorry, Titi wants to.
Thank you. I was just going
Sure.
to say that I could add to that. I totally agree with Professor Bradlow's answer as well. I just wanted to quickly add that one or some ways that scholars in the Global South can contribute to expanding teaching, there is use of some free resources that we have. So Professor Bradlow, for example, has been generous in contributing to Afronomics Law. It's a platform that disseminates information resources on international law with the critical perspective. There's just lots of free information there. I think that scholars in Global South can make use of those. We have other opinion juries, we have The Conversation, we have lots of other platforms, open access platforms that scholars could utilize. We could also have opportunities for guest lectures, for example. So if you know scholars that are specialists in particular subjects that you're teaching, and that perhaps the university or the school might not have access to resources to bring them over. I think one of the positives of COVID has been the expansion of the virtual classroom. So you can invite them virtually to deliver guest lectures in the classes, and I think those will help. Another that I learned at Warwick as well was the power of media, films. My supervisor then, Dr. Julian Rangnecker, he showed a very powerful film about medicines, the medicine industry, about pharmaceuticals and intellectual property, and that has always remained with me. So we could use media, technology, movies also to teach, and I think that we could be creative in the Global South, even though there might be limitations to some resources. We could just utilize some of the ongoing platforms that we have now to maximize our teaching. Thank you.
Thank you, Titi, for that addition. Professor Bradlow, the question that I would like to put to you is, you have talked about teaching values. Now, if we are going to do that, do we run the risk of becoming preachers instead of just teachers?
Thanks, Rizwan. I mean, that's an important question. What I always tell students is, you're not going to get a good grade in my course because you agree with me. What I want to see is that you know how to build an argument, that you understand all aspects of an issue, and you can reason and show that knowledge, and you reason your way through to a conclusion. If I might think your conclusion is completely mad and wrong, but that's irrelevant. As long as the analysis is rigorous and shows that you understand the issues, you'll get a good grade. If I agree with your conclusion, but I think your analysis is bad, you're going to get a bad grade. If you write a great answer and you reach a conclusion that I think is wrong, I'm happy to try persuade you that I'm right over coffee or a drink or something, but you're going to get a good grade for that. Our job is to make the students understand what the issues are, understand what they need to think about, and reach their own conclusions. It's not our job to tell and to show them why they need to reach a conclusion. It's not to make the answer for them. And so in that way, I don't think we're a preacher. We're more that, and that's why we're pushing them outside their comfort zone. Is we're saying, you haven't even thought about, all of us, I mean, and I'm not excluding myself from this, you haven't thought about, and unconsciously you've accepted certain things that you need to challenge, because the world's changing. If the world was perfect, you could go on thinking what you currently think, but we know the world's not perfect. You need to think more critically about what it is that we think about that is blinding us to solving some of the problems that we could solve. And so that's my way of avoiding that. If I could just add one thing, I don't know if the ASIL interest group is doing that, but one of the things that would be very helpful to people, particularly in developing countries, is if there were a center where you could go and get teaching materials freely available on one website where we could share information, so that people in Africa could learn what's going on in Bangladesh or Pakistan, for example, and adapt some of those materials to be used in their part of the world, and vice versa.
Thank you. I can see one of our colleagues has raised hand, as Wes has just typed in that we do not have the option to let audience join via microphone. So please type in your question. We'll try to put your question to either TT or Danny, whoever you want to address. Danny, you remind me of my teacher at NUS, Professor M. Shawnaraza, who used to tell us that never agree with the teacher, because that's one of the easiest tasks that students can achieve. So the next question from me would be, are we doing enough in discussing the less talked approaches to international law, let's say Int'l or feminist approaches to international law? I was wondering what happens in your law school, Pretoria, or maybe in other law schools in South Africa or other places of which you are aware of. Any thought on that?
It's a good question, and to be honest with you, I don't teach the LLB students, the basic law students at the University of Pretoria, and so I don't know exactly what goes on in the international law class. I know that it's a very big class, and that has limited the sort of creativity that could happen. In the LLM programs that we run in the Center for Human Rights, these issues come up. They may not come up in the sense of having a formal lecture on Int'l as an approach to international law, but it would come up in the way in which problems are addressed and the kinds of this choice of problems that we seek to address and try resolve. And I would say most of the students would be required to do some reading that would push them to look at the writers in these different approaches. I can't say it's being done as much as it should be, but it is being done to some extent.
Thank you, Danny. The next question would be, how can we, let's say, draw a balance between preparing professionals and sort of setting some value questions in them, in our students? Do we focus more on the technical aspects, try to make them better professionals or more successful professionals, or maybe people who would only be concerned or predominantly concerned with values? Or do you see no sort of challenge or inherent tension between the two motives? Your thoughts on that?
I mean, as Titi said, international law is political, and that means there's a normative component to whatever we do. And so that separating values and doctrine is not easy. But there's no question that we cannot have lawyers who graduate and who filled with good ideas on justice, but don't understand how you use the technical legal doctrines and legal techniques to achieve those just ends. So there has to be a mix of both of them. But what you want is your students to understand that whatever choices they make in terms of techniques and whatever doctrines they choose to apply have normative implications, and they need to be aware of those and understand what choices they're making implicitly, if not explicitly. And our job as teachers is to say to them, you know, as it should be explicit, at least in your mind. Maybe you decide for various reasons you're not going to tell your client, or you're not going to write about it in the paper that you're writing, but you must understand what choices you're making and how that influences the conclusions you come to and the way in which you construct your arguments or the advice you're giving to your clients.
Thank you. My last question to you would be, I guess you are teaching for many years, maybe for decades. So do you notice any change in approaches to teaching international law in Africa or in other parts of the developing world?
Yes, I'm an old white guy who's been teaching for many years. I taught most of my teaching was at American University, and I've been teaching in Pretoria now for about 15 years. And I would say, if I look at my students, their views have changed and the issues that concern them have changed. I would say technology has opened up possibilities in terms of teaching, even pre-COVID, that didn't exist before. The course I was telling you about in the book that I developed, in the simulation course with Jay Finkel, the book that I wrote with Jay Finkelstein, that course was originally developed, and the first time it was taught, I taught it with the late Thomas Waldy at the center at the University of Dundee. And we did it over email with a video conference for the very last session of the course. And at the time, I didn't know anybody else who had done anything like that. Now the course is taught, the whole thing is over Zoom. So the students are interacting on a weekly basis with students all over the world, which could never have happened before. We can have lecturers now based in any city in the world who come and teach in Pretoria, and the only constraint is time differences. So the possibility that opens up possibilities. It has some drawbacks, as we know, but there are possibilities for that. I would say the issues have changed. I mean, climate has become a much more pressing issue. I would say when I started off, questions of human rights in business and the economic realm were viewed as completely outlandish. They're now much more mainstream. Exactly what that means and how we apply it is still something that's being worked out as we speak, I suppose. So it is changing. I think even in peace and security, and sort of the more classic fields of classic topics of international law, things are being rethought because of the work of people in Int'l or feminist approaches to international law. That their views are changing the way everybody thinks about these subjects. I don't know, Titi, did you want to add anything to that?
Thank you, Danny. I would say that perhaps maybe the mediums or the approaches to teaching might have also expanded because of the technological developments that we've had. So that has exposed us to just having more variety in our teaching. And I'll say that students, well, I've been teaching not for as long as Professor Bradlow, but I'll say that I've noticed that students have also, the types of questions that students ask are now more challenging. So they're able to tell me that they read something in the news yesterday about food, and they want to, and they're sharing their opinions about what a resilient food system should look like and how that would apply in their country, in Germany, for example. And they're giving me practical life examples of what is happening as a result of the pandemic. So I think that students are now more engaged, perhaps, with some of the contemporary issues, and that could also be one of the outcomes of COVID, because I saw that from last year, I could see more engagement with the news, and we were just discussing lots of topical issues more in class. So that's one of the changes I've noticed.
Thank you, Danny. Thank you, Titi. Maybe Titi, what you are saying, I would see it in a way that we are not only pushing our students to think beyond the box, they can also push us to think beyond the boxes. So with that note, we are almost out of time, I guess. So thank you very much, Professor Badlow, once again, Dr. Adibola, for your time, and the audience for your participation. Have a good day.